Hi, everybody. I'm Brittany Lewis, a breaking news reporter here at Forbes. Joining me now is First Amendment attorney Jeff Lewis. Jeff, thanks so much for joining me once again.
Yeah, thanks for having me.
There is a big case, a big defamation case that I would love to get your insight on. Last week, the Wall Street Journal ran a story on what they described as a bawdy letter President Trump allegedly wrote to Jeffrey Epstein on his 50th birthday. And according to the Journal, it included a drawing of a naked woman and Trump writing, quote, "Happy birthday, and may every day be another wonderful secret." President Trump has vehemently denied he wrote this letter and he drew that drawing, saying he doesn't draw pictures of women and saying those weren't his words. He filed a defamation lawsuit against the Journal, the reporters, and Rupert Murdoch, the founder of News Corp, which essentially owns the Journal because it owns the Journal's parent company. So to start off the conversation, what are your thoughts on this lawsuit?
My thoughts are President Trump has a big hill to climb to win this lawsuit. There are three big obstacles in Florida he has to overcome to win this case. He's got to prove actual malice, that at the time the Wall Street Journal penned this piece, that the Wall Street Journal's journalists didn't believe subjectively in the truth of this piece. It's called actual malice. Very hard to prove that. Second big hurdle, Florida's got an anti-SLAPP law, which means immediately Trump's got to prove his case up or face dismissal. And then third, and most importantly, in Florida, before you sue a media defendant like this, you have to give 5 days notice. Hey, we're about to sue you. And as far as I know, it hasn't been reported whether or not he has given such notice.
And I want to read some words from the lawsuit. The lawsuit says that the story has, quote, glaring failures in journalistic ethics and standards of accurate reporting. And then it went on to say this, quote, the reason for those failures is because no authentic letter or drawing exists. Defendants concocted this story to malign President Trump's character and integrity and deceptively portray him in a false light. This lawsuit is to the tune of billions of dollars. So, I mean, how do you do that? How do you say that prove that this story had these glaring failures, that these journalists concocted this just because they hate President Trump, essentially?
Yeah, to prove up a case like this requires specific facts that a journalist knew that the statements were false and proceeded anyway. And just saying, hey, you don't have a copy of the letter doesn't mean that the journalist knew at the time that the article was written that no such letter existed. We don't know if a letter exists or not. So I will say this, there are two claims pled in the complaint, one for defamation per se and one for defamation per quad. One of the claims doesn't even require any proof of actual damages, meaning if President Trump can prove that his reputation was harmed by a serious allegation, he doesn't have to prove a nickel of damages have been actually incurred to win, but he does have some hurdles, as we've discussed earlier in the interview.
And the lawsuit seeking $10 billion in damages for each count of defamation. There's two counts of defamation, meaning that if my math's correct, it's adding up to at least $20 billion. So that's a huge number. Do you think that adds anything to this case? And do you think that's worth what President Trump is suing over?
Well, look, anytime you're sued by a president of the United States, there should be, or a big celebrity or a big well-known politician, it should be of concern to the defendant. On the other hand, what should give the Wall Street Journal pause, the thing that should cause um, concern for the Wall Street Journal is whether things outside the courtroom could be brought to bear to silence the Wall Street Journal. We've seen executive orders from this president targeting law firms or targeting mergers and that kind of thing. It's those kinds of pressures that should cause Wall Street Journal concern. But there's nothing in this lawsuit, based on the facts that are alleged, that should cause the Wall Street Journal's lawyers to lose any sleep.
Okay, that's really interesting. So President Trump saying the Wall Street Journal got this wrong. You're saying, President Trump, you don't have that strong of a case.
Here's why I say he doesn't have that strong case. First of all, he didn't allege that he complied with the 5 day rule in Florida. He doesn't allege any real specific facts that the reporters knew, for example, that their witness who gave them this letter was unreliable, or a fact that such claims have been debunked in the past. There's very few specific examples of facts that would put the Wall Street Journal on notice that their story was false. That's why I say this kind of case is very hard to win for President Trump.
So then, because you're saying that President Trump has an uphill battle to climb here, what's the likelihood of this case even getting dismissed in the first place?
It's going to get dismissed early on, and I expect the Wall Street Journal will bring either what's called an anti-slap motion to dismiss or an early motion to dismiss testing the merits of the case on this issue of actual malice and or this 5-day rule in terms of whether or not President Trump gave 5 days notice to the newspaper before suing it. There's going to be an early testing, and that dismissal order or the failure to dismiss the case will go up to the Court of Appeal pretty early.
And do you anticipate that this case gets dismissed or it goes onward to the next step?
I would expect this case to be dismissed unless there's some fact that wasn't pled in the complaint that President Trump is holding close to his vest. But based on the facts as pled in the complaint, I would expect it to be dismissed.
If this case doesn't get dismissed, I want to talk about the discovery process because President Trump, as we know, is trying to distance himself from disgraced sex offender Jeffrey Epstein. But would he be forced to turn over anything in this discovery process that perhaps paints a different picture, perhaps would show that he has a bigger relationship with Epstein than he's trying to show?
You're absolutely right. If this case survives the dismissal stage, the motion stage, there will be discovery. And the areas for discovery that he could be required to turn over evidence to could include depositions, could include whether or not he draws or not, could include communications or correspondence with Epstein, could include even, this may sound far-fetched, but there's been media reports that Trump's administration has been scanning the criminal records regarding Epstein for mentions of the word Trump. And even those efforts could be subject to discovery. So it's pretty broad what discovery could find in this case.
And I know we're looking down the road here, but Ghislaine Maxwell was allegedly the person, according to the Wall Street Journal's reporting, the person who put together this book of letters for Jeffrey Epstein. Could she be called in to testify in this case?
Absolutely, I would expect her to be called in to testify both at a deposition and then ultimately at a trial. The fact that she's currently serving time is not a barrier to her testifying at either.
And how would the Wall Street Journal reporters defend themselves here from President Trump? Would they have to give up their sources? Would they have to show the letter? Should they have that letter? Because the letter was not printed, and that was something that President Trump took issue with. Would they have to show that to the president and say, hey, this is the person who gave it to me?
How they'll defend this case is, first of all, they'll say truth and they'll rely on that 5-day rule I talked about before. But in terms of discovery, most states have shield laws that protect journalists from having to reveal their sources. But having to produce a copy of that letter is not the same as revealing a source. They could turn over a copy of the letter without, for example, turning over the email or details about the meeting in terms of how they obtained the letter or where they obtained the letter from.
And were you surprised by this lawsuit at all as someone who is a defamation attorney, who this is your field here? I mean, were you surprised that President Trump took this kind of extraordinary step?
No, President Trump, forecast he was going to do that. I was surprised they picked Florida. They had a few different choices of where they could sue. Florida has a pretty strong anti-slap law, a quick way to get rid of cases like this. So I'm kind of surprised they didn't do more forum shopping looking for a state with a weaker anti-slap law.
And so then what should we be looking out for next? I know that this lawsuit was just filed last week.
Yeah, so the first thing you should look for is either an anti-slap motion or motion to dismiss brought by the Wall Street Journal and the other defendants, or it's possible President Trump got this lawsuit filed in a hurry. He might file an amended complaint with more facts regarding the notices he gave and additional facts showing that the defendants acted with actual malice. Those are the next steps.
Well, Jeff Lewis, as we see these next steps play out, I hope you can come back on and break them down. Thank you so much for joining me. Thanks for providing your insight, your expertise here, and you're welcome back anytime.
Of course, thanks for having me.